Hello. One difference makes a lot of confusion, at least when it comes to a regular person without specific legal training. That's the question about the difference between civil and criminal law, procedure, and so forth. Criminal, for the sake of this discussion, will include the penal as well, though there is some difference between the two. But still, civil versus criminal. There are several differences, several major differences. There are many like small ones. And one of them, at least in my opinion, is the critical, the main difference. So, what are they? When it comes to criminal law, criminal prosecution, criminal pursuit, it's the government, the state, the crown is going against a person. Even though the crime, alleged crime at least, was perpetrated by a private person or by a company or sometimes even by the state itself, at least through the representatives, the one like prosecuting, the one going after is invariably the state. Well, when I say invariably, the criminal code allows a private person to go there, but in reality, that doesn't happen often. So normally, it's the state, meaning that if there was a victim, there was a complaint, there was police report, there was an investigation, and then the Attorney General or representative of the Attorney General decided to pursue, then the victim cannot simply withdraw the case because it was not the victim who initiated the case. It was the state, the crown, the government. The victim can refuse to testify or to a certain extent, but still, once initiated, the person who made the initial complaint has no little power over what's going further on. In the civil litigation, where two, like virtually, or two or more, virtually equal parties are arguing their case before a judge, in such a situation, even the state, the government, if it's sued or if it's suing, is presenting itself as a party, as a person. So there might be a neighbor, a friend, whoever around, might be a company, might be a private person, and the lawsuit is going against another person or against several other persons in that sense. And if there is a settlement, there is a settlement. If the plaintiff wishes to withdraw the case, it's up to the plaintiff to withdraw the case. So at the end of the day, in a civil litigation, parties have more power over what's going on. And what's important, more power to just put an end to that litigation. It's more, in a sense, commercial. Therefore, mediation and arbitration is quite common in civil law, in civil conflicts and civil litigation, but less possible when it comes to criminal. Also, the constitutional right for a lawyer applies to criminal cases, meaning that if you don't have means for a lawyer, the state is normally, usually, would provide, unless you specifically just waive this right. In civil litigation, but for special situations like a liquidator of an estate, for example, or a general manager of a company, where you must have a legal representative, a lawyer. In most cases, you can go without a lawyer. Both parties can go without lawyers, which is usually sort of a nightmare for a judge, but, well, it depends on the situation. In a small claims court, for example, lawyers are not allowed. Parties go without lawyers, by default. So, well, again, there are situations, but the general rule is like that. So again, there is a difference. This difference is justified by the fact that usually in a criminal case, in a criminal litigation, the risk for a person is significantly higher than in a civil litigation. Because in a civil litigation, the freedom is not at stake. Uh, like stigma, that's like public stigma is not at stake. Future generally in that sense is not at stake. In civil litigation, most of the time it's about money. Of course, it can still be life-changing, and there are also like family issues where there is a question of child custody, uh, mm, access to relationship with your kid. Uh, in civil litigation, there might be a situation of personal capacity or incapacity, or medical treatment and access to that medical treatment and consent to that medical treatment. But generally, the consequences are less atrocious, less grave for a person in a civil litigation. And again, most of the time, it's just about money, about property, about some assets. Uh, But to me, the most important, at least from a legal point of view, the most important difference is the burden of proof. In a criminal case, the crown, the government, the attacking party has to prove that somebody is guilty beyond a reasonable doubt, meaning that if there is any doubt which is not like capricious, idiotic, but just at least some reasonable sense in there, that doubt should be interpreted in favor of the accused. So it's harder to prove guilt in a criminal case. In civil litigation, it's a so-called balance of probabilities, meaning that for a judge, one outcome should be just a little bit more probable than the other, which means that usually it's explained like 51% in favor of one of the probabilities, meaning that the civil litigation leaves, like implicitly, inherently leaves this possibility that maybe there was something else. So basically, the judgment is, in that sense, is technically 51% correct. Well, I am stretching it, but you see the idea, meaning that judicial justice system cares less about the bulletproof correctness of the judgment in a civil litigation than in a criminal one. Again, because the consequences are less significant to the life, to the non-property rights of the person. Let's put it this way. It doesn't mean that you don't have to bring good, solid evidence, even if you're in defense in a civil litigation. And the question of evidence is still very important. But in a civil litigation, for the judge is like more or less equal footing from the start, while in criminal litigation, or the presumption of innocence, with all the exceptions though, but still, by default, if the government is in attack, the government has a very high bar to prove, legally speaking. I'm not talking about like this and that particular example, but legally speaking, the bar is significantly higher, which means that in a civil litigation, in fact, there is no such a thing as presumption of innocence. It's balance of probabilities. Thank you, and have a nice day.